it is. It is your girl Cadillac. Okay, well, let's zoom in. Hi, I am Cadillac Dixon. I'm setting up. I'm sorry. I'm Cadillac Dixon. Maybe I'll do that once I sit down. I'm sorry, y'all. Just give me a second. Let's get this light on. Light that's gonna blind my eyes. The lighting in here is not that great. I hope that's decent. I don't know. We doing whatever we can do till your girl purchase another device. And where did my mouse go? I'm sorry guys for pushing live before being ready. Let's cut this air conditioner off, though it's hot. But the air conditioner is basically making a lot of noise. Hold on, it's crooked. Really? The camera's crooked. Girl. Sorry, my contact bothered me too. Everything want to bother me. I know that's the devil just wanting to stop me on when I am on a roll. Okay, so today, first let's do the intro. What it is, you guys, it is your girl Cadillac. Yes, I'm Cadillac Dixon. I'm the Drama Life Prison Wife. I'm the legally blind. Oh my contact. Girl, I'm the legally blind artist that is rapping and painting for justice. Hoping, girl, to see justice before all fades to black. Yes, it's your girl Cadillac. Oh, girl, this contact going to be up for real. Okay. Ugh. The problem being I fell asleep with my contact in. So, yes, I am a legally blind artist. I am losing my eyesight. I require a cornea transplant, which face the black mean I'm trying to get my darn husband home before I go blind, girl. Because once I go blind, I can't do all this. Like, this is now or freaking never, which was the title of my first album that I recorded with hopes of breaking my husband's wrongful conviction story, getting him home. So I have basically been in so many different ways. The camera is still crooked. In so many different ways, I have been trying to break my husband's story. When one method doesn't work, I try something else. That is the whole purpose and point of my YouTube. That's the whole purpose and point of my project Reach the World. That was the whole purpose of me rapping, to get my husband the heck home and then take several seats, girl, and live life like everybody else do. Ain't nobody else that I see around me fighting, the fight of their life. They just live in life, girl. And that's what I want to do. But through being fighting for my husband who was wrongfully convicted, it has showed me my passion and opened my eyes to this bogus justice system that we have here in Florida. But I can imagine just by being in different advocacy groups all over in Texas, Illinois, Mississippi, New York, the DOCs, well, yeah, the DOCs, but the court systems as well. They're all messed up, corrupt. They do not do things the way that they should do things. And I mean, that's just how it is. So I'm trying to bring attention to that. I'm trying to get my husband, basically, I was trying to overturn his freaking conviction, his wrongful conviction. But if we cannot overturn it, like, girl, they need to sentence him correctly. Like, the whole trial was botched and messed up. And they gave him this hefty sentence. So that's what I'm trying to do. So thank you guys for being here with me. If you did read the description box, yes, my husband, Marchello Jackson, the wrongfully convicted Florida man, convicted with no fingerprints, no evidence, no eyewitnesses, just the people that allege that they were robbed. Those are your only witnesses. No street witnesses, no canvass of the neighborhoods. They tampered with evidence. They changed evidence. You have officers conflicting one another. They all were present, but they all have different stories. You have the two that were robbed claiming they were robbed, having two different stories. So you have just a circus. And at the end of the circus, and you charged him with, he was charged with a weapon, which weapon enhancements took the crime from being worth 10 years in prison and escalated it to 40 years. You never recovered, they never recovered the weapon per se. I believe they're lying. But let's go with what they're saying, because they're God. Yes. So they never recovered the weapon, but they're charging Marchello with having a weapon, which escalates his charges from 10 years to 40. Really, how we get to 40 is because the judge said he really wanted to give Marchello life after this. Life in prison means completely gone. There is no parole system in Florida. Had Marchello been in any other state that does have parole, possibly he could have been up for parole by now, because he has done 21 years wrongfully. He's done 21 years in prison. Okay, so when I say he's back in court, the regular courts where everything was sealed off in 2002, where people can't see what's happening behind those courtroom doors, where people are just assuming that, the judge took an oath to uphold the law. The officers took oaths to protect and to serve. So there's no way they're not going by the law. The state lawyers and stuff, they took oaths to defend justice. Justice is what's right. It's not what you want, it's what's right. They took oaths. So, of course, we can leave this to just them because they're going to do the right thing. That's not what they do, because we're leaving them to decide things on their own. That's what they're doing. They're deciding on their own how to handle stuff. They're not necessarily doing things by how they should be done by law. So, Marchello was tried in a court of closed off biased opinions. But now I'm finna read this transcript to you guys, and y'all try Marchello in public opinion, because that's where Marchello needs to be tried, out in the public with people that can see, okay, does that make sense? Does this make sense? Does these two puzzle pieces fit together? Does Marchello actually fit being the culprit of this crime? Or does somebody else fit being the culprit of the crime? Or in fact, are we even trying Marchello on the correct crimes? If in fact the crime took place, is it the crimes that they are bringing forward that took place, or did something else happen that night? That is what we're going to do. We're going to read through the trial. Y'all know yesterday, I see some people did watch it. I thank you. I mean, thank you so much, because this is my life. Unfortunately, this has been my life since I was age. Let me see. Me and Marchello, I met the love of my life at 18 years old. I met Marchello at 18. Girl, I was so head over heels in love with this man. And it's not because, girl, you crazy, you can't find nobody else. No, Marchello is not like any other man. I have never met a man that is so attentive. He has, he, he was just so perfect. He was opening doors. He was just always being there, always present. When he became a father, when I had our daughter at 20, he was always there. He was at every single doctor's appointment. He was working. He was helping me take care of our daughter. Now I think I'm too close, girl. I'm sorry. I don't do too many lives. So I'm trying to figure this out, girl. Okay, zoom back out. So, okay. But I can't explain it no other way. I had other men, and no other man treated me the way that Marchello Jackson treated me, like a freaking darn queen. A queen. And I know that that day that they sentenced him, the day that Marchello lost his trial, I literally ran out. When we get to it in the trial, they changed the transcripts, I see, because what they have is a little space cutting out what the judge really said to me. They got these two dashes. He said, if I could not contain my cries, you're breaking my heart in front of me. You are sentencing my husband to 40 years, 40 years, 40 years for all these bogus charges. And he tells me, if you can't control your cries, I'm going to hold you in contempt of court. That is what he said. But they blanked that out in this transcript. That's what he said. So I ran out the courtroom. I ran down the escalator and I ran outside the courtroom and I laid in the freaking street in front of the courtroom. I just laid there in the street because they have broke my heart. They literally, we was on the path of having a perfect family. We just had our freaking daughter. We just had our daughter. We was getting married. We was trying to get up on our feet. We was only freaking 20 years old. 20 years old. We had our whole lives ahead of us, our whole life to, and this is, it's like, it's traumatizing to me. Number one, because girl, you had this perfect freaking life. And then within an instance, it's snatched from you and never to return again. Like, that's very dramatic. And I know everybody say, girl, you could have found somebody else. Baby, I dated. Ain't nobody else another Marchello Jackson. There's one. There's one. There's one soulmate for me. There's one for me, Marchello Jackson. So what we are finna do, we're going to play through this trial. Yesterday, I did release, you guys did watch it. If you would like to go watch it, it is in the playlist, Free Marchello Jackson, Wrongfully Convicted Florida Man, that playlist. It starts off with talking about C murder. I'm sorry, I want to stop calling, it's a habit, y'all. I want to stop calling him C murder and I want to call him Corey Miller, because we have to put faces and humanize people, because right now what they do in this system, in these courts, you're a number, your docket number, your inmate number, your number this. Who cares about numbers? Do you think an accountant cares about crunching the numbers that he crunches? He don't give two darns about it. These are humans. So when you realize you're dealing with human, you treat it differently. What if a doctor only seen his patients as numbers? Patient number one, patient number two, how my mother was treated, and which led to her wrongful death. What if your doctor treated you as just a number? So we have to treat them as human. They are human. Okay, so he goes into the case. It starts out as the case of Corey Miller and him taking a stand, basically bringing attention to the inhumane conditions in Louisiana DOC. But girl, Florida DOC ain't no better. Inhumane there, let me tell you, there is no freaking AC. That's what we've been fighting for, to get AC. Do you know how hot Florida is? Most of the year, there is no AC in the prisons. None at all. So they are sweltering, compacted in cedar block cells where it holds in more heat. So it's more hot inside the DOC than outside the DOC. We did a beat the heat challenge where a formerly incarcerated woman showed us. We went in the cell, so we were asking lawmakers to do 5 minutes in what you sentenced my husband 40 years to, and what you're sentencing so many to life to just do 5 minutes in this cell and see how it feels. Half of them couldn't do it. Half of them couldn't do it. Half of them was like, what? We don't have AC in prison? Like, why? It's so hot. But basically bringing, humanizing the people. Humanizing people that are in prison. And they've already been convicted of whatever crime they're in. When you go to prison, you've already been convicted. So it is not upon the prisons to treat you inhumanely, because you've already been kind of given your punishment, crime and punishment, which should always be equal. You should never get a punishment that's this big, but the crime you committed is this big. That doesn't make sense. That's unequal justice. You should get the time. So that as well in my husband's case, already he's wrongfully convicted, but the sentences that they gave him were worth up to 10 years, and they escalated it up to 40 years. And the judge was saying he's being lenient on Marchello because he in fact wants to give him life. But just so he has a second chance at life, he is only gonna give him 40 years. Okay, so let's get into the beginning. This is gonna be the beginning. I do already have the testimony of the three officers, law-abiding officers that conflicted with one another. Their testimonies didn't align, which you do know one of those officers, the arresting officer in Marchello's case, is also accused in another case in the state of Florida of a guy saying that they were chasing a suspect. He carjacked this woman, he robbed this store, he did all this stuff, and then they were able to shoot him down. Okay, but we're the gray area because that's justified, that okay, he committed a carjacking, a robbery, okay, you know, we're doing our job. But then it went on to say that they say he picked his arm up and was able to continue trying to fire at them. So they said they fired 49 more times and outed this guy when they were supposed to just arrest him, take him to the jail, then get him some charges, try him in this biased ass court, and then take his life that way. That was how they were supposed to do it. But instead, that officer plus 4 others decided to, it was overtime for him. This is the same officer in Marchello's case that wrote up these charges on Marchello and came to court and basically lied. I do, in that video of me going through the 3 different officers testifying, their testimony, in the description box, I was able to write and timestamp each place where their testimonies were not lining up. So you get to hear all 3. That I just released that yesterday. All right, so let's get into it. Yes. The Circuit Court, 9 Judicial Circuit Criminal Justice Division in and for Orange County, Florida, Division 19. The state of Florida versus Marchello Jackson. Yes, the whole freaking state. And that's for real. Okay, jury trial proceedings before the Honorable. Now, I remember I said I'm just going to use the people's last name because I'm not necessarily trying to incriminate nobody. No, I just want Marchello freaking home. I'm just trying to break his story of being wrongfully convicted. So I don't have to, though the consequences of them lying, of them throwing things off on Marchello, or whatever they did, they have to serve those consequences with God. God got to deal with them. Even that officer, God got to deal with them. I just want my husband home. And that's my whole purpose in this. Get him home before Jesus comes back. Okay. It has appearances by state attorney, assistant state attorney at the time, Brennan. Her name is Miss Brennan. Marchello's public defender, Mr. Sims. Okay. And now we're going to go down and we're going to start. Okay. This is Tuesday, April 9th, 2002, 3 p.m. I hope I have the right transcript in front of me because it's 4 parts. Okay, everyone, please rise. This is the court deputy. The Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida is now open. The Honorable Judge Cohen, judge presiding. And since then, Judge Cohen has gotten several raises. He is now a Supreme Court judge. He's no longer a Circuit Court judge. Okay. So anytime I say the court, it refers to, it's written like it's a script. So anytime I say the court, it refers to the judge. Okay. So the court, please have a seat. The clerk. Okay, the state of Florida versus Marchello Jackson. This is like a stage play, girl. I told y'all it's like a stage play. Okay, the court. State ready to proceed? Ms. Brennan. Yes, Your Honor. The court. Defense ready to proceed? Mr. Sims. Yes, Your Honor. The court. Good afternoon, ladies and gentlemen. We are here for jury selection in the case of the state of Florida versus Marchello Jackson. The purpose of the jury selection portion of the trial is to pick a fair and impartial jury, both for the state and for the defendant. Marchello did not have no. Whew. Okay. The way we go about doing this is by asking some questions of you. We don't ask those questions in an attempt to needlessly prior to your background or personal affairs. And if there's a question asked of you that you don't feel comfortable answering in the presence of the rest of the jurors, let me know and I'll be happy to bring you up to the bench and let you answer and let you answer in a little bit more private setting. And we're going to accomplish this really, I would say, by about 5 o'clock today. And the reason that I mentioned that time frame is within the time frame. Now, in the last one, when I was reading I was about to say the script, the transcript, because it is like a script. It's a stage play, girl. It ain't real. When it does the little double spacing, the dash, I'm just going to pause so that lets you know there's a space there. Okay, within the time frame, and we may go a little bit after that. There is no way that the lawyers can ask every possible question that bears upon your ability to be fair and impartial. And so, if there is something in your background, whether it's an experience that occurred to you or a relative or a friend that you're not sure whether that would impact upon your ability to be fair and impartial, volunteer that information to the lawyers. This is the only day in court for the state, and the only day for Marchello too. It's the only day in court for the defendant. Yes. And it's important when we get done with this case that we have a fair and impartial jury to try this case. Now you'll know that we have a young lady seated in front of you that's taken down everything that occurs during the course of the trial. She is very good at what she does, but as good as she is, she's not yet perfected the technique of getting down your thoughts or of getting you nodding your heads. And so when questions are asked to you, we are going to need to have you answer those questions out loud. Would you do that for us? Prospective jury, affirmation response. So they all affirmed. Whereupon the jury selection proceeded, and the jury was duly sworn by the clerk at 4:41 p.m. The court. Could we have the lawyer's approach? Whereupon the counsel approached the bench and conferred with the court out of the hearing of the jury as follows. The court. Since we have the other verdict in, I think what I'll do is just let those folks go. Mr. Sims, no preliminaries or anything. No preliminaries or anything. Question. I guess that's a question because it has a question mark. No preliminaries or anything, so that's how it should be asked. I don't think you need to. The court says no. Mr. Sims, we'll just do it all in the morning. The court. We'll do it all in the morning. Mr. Sims, 9:30? Question mark. The court. I have a 9:30 sentencing. We'll do it right after that. It's not a real big deal, I hope. Sentencing ain't a real big deal, girl. Mr. Sims, okay, thanks. Whereupon the bench conference was concluded. The court, folks, I was going to go a little further tonight, but I have the case that I am trying during the course of yesterday, and today we just have a verdict in it. So rather than have to juggle you all around, I think what I'm going to do is just let you go home now, and we'll finish this case tomorrow. So I'm not going to make you come back a third day. I don't think that should be a problem for us. Now, you really don't know much about the case, so there's really nothing to talk to anyone at home about. But you have heard a little bit about it. You've heard the allegations, and you apparently know where it occurred. We would prefer that you not discuss that with anyone, that you go home to this evening in case they might be, this reading makes no sense to me, I'm sorry. And I'm legally blind, so it's hard to see this black on white girl, but we gonna get through this. Okay, we would prefer that you not discuss that with anyone that you go home to this evening in case they might have heard something or know something about this case, because we want the case tried here in the courtroom and not at home where you have no idea, the people might learn or know. Baby, the courtroom ain't no safe place. And so the court deputy is going to give you directions and instructions on where to reconvene tomorrow morning. I'm going to have you here at 9:30. I do have some other matters that I'm going to be hearing in another case, but I don't think that I would be any longer than 9:30 or very soon thereafter before I can get back to you. And so with that, have a good evening, and we will see you tomorrow morning. Yes, sir. Did you have a question? Juror number 1406. How late will we go tomorrow? Girl, they already want to get out of there. Okay, the court. I don't have control over how long a jury deliberates, and so I can't predict with certainty how late you will go. So if you have plans, you might want to make some tentative plans. You'll have a pretty good feel by early afternoon in the terms of what the schedule will be. Is that helpful? Jury 1406, yes. Court deputy, right this way. All rise for the jury, whereupon at 4:45 p.m., this proceeding was in recess to reconvene at 9:30 a.m. the following day. Okay, I'll be right back, guys. Right back. 1 second. I had to do this on live because y'all know my phone is missing. I have no other way to record. And yesterday when I did record the reading of the three officers' testimonies, when I did that, it held up so much storage on my sister's phone that I'm borrowing now. So I decided so that it can just free the storage. It literally took me all day yesterday trying to upload that. So to avoid that and just keep on bringing content, I decided to go live. I do think my lives do not do as good as my regular videos. So I am taking a blow on that by doing it through live, but I don't know. I don't know what else to do. I got to find some way to find a backing to get to the purpose of everything that I've done since 2002, since the day that Judge hit that gavel on that desk. Okay, so Wednesday morning, April 10th, 2002, 9:45 a.m., the court. All right. Are we ready to go on with the trial? Yes, Judge. Where's your client? Sitting on the couch. All right, that's Mr. Sims said that. All right, have him come in. Mr. Sims says, Your Honor, are we calling for the jury? The court, we're going to. Mr. Sims, there's a preliminary instruction in this case. I would like for you to include the defendant not testifying. Okay, the court, I always do. Mr. Sims, I know the rules say included it if it's requested. I want to make sure it's requested. The court, I don't require it to be requested. I read it as a matter of course. Mr. Sims, and I would like to invoke the rule. The court. All right, let your witnesses know the rule has been invoked. Ms. Brennan, yes. The court. All right, go ahead and bring in the jury. Court deputy, yes, sir. Everyone, please rise. The jury is entering. Whereupon the jury entered the courtroom. Court deputy, please be seated. The court. Good morning. The jury. General, good morning. The court. All right, ladies and gentlemen of the jury, you have now been selected and sworn to try the case as the jury to try the case of the state of Florida versus Marchello Jackson. Before I begin with some preliminary instructions, let me take just a couple of moments to introduce you to some of the other personnel that you're going to be dealing with during the course of the trial. You had an opportunity to meet the lawyers, and I briefly introduced Mr. Jackson. I spoke earlier about the role of the court reporter who now sits between us. It's her responsibility to make sure that we have an accurate record of everything that occurs during the course of the trial. As a result, if two people are speaking at the same time, or if someone is speaking in a matter that cannot be understood, it's her responsibility to stop the trial and let us know that she's unable to get an accurate record of what's occurring. To my left is sitting one of the assistant clerks of the court. His job is to swear the jurors in and to swear the witnesses in. He keeps track of the evidence in the case. He keeps court minutes, keeps track of paperwork within the files, keeps track of the files themselves, and any paperwork that we generally, from here in the courtroom, that we generate. Yes. I'm sorry, y'all. I'm trying my best to read, girl. He's responsible for that as well. In the corner of the courtroom, you will see a couple of the court deputies. They are in charge of courtroom security, and they will escort you to the jury room when that becomes appropriate. It's indicated to you this is a criminal case. The defendant is charged with 2 counts of kidnapping with intent to commit a felony, 2 counts of carjacking, and 2 counts of robbery. All 4 of those counts with firearms. The definition of the elements of those offenses will be explained to you at a later point in trial. It's your solemn responsibility to determine whether the state has proven, girl, can we highlight that? Has proven its accusations against the defendant beyond a reasonable doubt. Your verdict must be based solely on the evidence or the lack of evidence in the law. In the law, they have no evidence. So, God, okay, the information which charges those offenses, alleges those offenses, is not evidence, and is not to be considered by you as any proof of guilt. It's my responsibility to decide which laws applies to this case and explain those laws to you. It's your responsibility to decide what the facts of the case may be and to apply the law to the facts. Thus, the province of the judge and the province of the jury do not overlap. And that's one of the fundamental principles of our system of justice. Before proceeding further, it would be helpful if you understood how this trial would be conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the course of the trial. What the lawyers say is not evidence, and you should not consider it as such. Following the opening statements, witnesses will be called to testify under oath. They'll be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the presentation of the evidence, the attorneys then will have an opportunity to make a final argument. Following those final arguments, I will then instruct you on the law applicable to this case. Following that, you will then retire to consider your verdict. You should not form any definite or fixed opinion about the merits of this case until 3 things have occurred. 1, you have heard all of the evidence. 2, you've heard the arguments of the lawyers. And 3, you've heard the law that I instruct you on at the conclusion of the case. Until that time, you should not discuss this case among yourselves. During the course of the trial, we're going to take certain recesses, during which time you're going to be permitted to separate and go about your personal affairs. During those recesses, do not discuss the case with anyone, and you should not permit anyone to say anything to you or in your presence about the case. If anyone attempts to do that, let them know that you are on the jury trying the case, and ask the person to stop. If the person does not stop, leave the person at once, and at your earliest opportunity, report the matter to a court deputy. They will report the matter to me, and I will take appropriate action. The case must be tried by you only on the evidence presented during the course of the trial in your presence and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. Accordingly, you must not visit any of the places described in the evidence. and you should not read nor listen to any reports about the case. Further, you must not discuss this case with any person, and you must not speak with the attorneys, the witnesses, or the defendant about any subject until your deliberations are finished. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inferences of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rule of the evidence and trial procedure. It's their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you should not speculate on what might have occurred that the objection not been sustained, nor what a witness might have said if the witness had been permitted to answer. We have provided for you legal pads and pens, and that is because we give you the option if you wish to take notes. That's an individual's decision. If you wish to take notes, you may take notes. If you don't want to take notes, you don't have to take notes. We don't want you to get so absorbed in taking notes that you miss the next question or the next answer. However, we do not discourage the taking of notes. When you go back to deliberate, the recollection of the juror who's taken notes should be given no greater weight than the recollection of a juror who hasn't taken notes. Or to put it another way, the mere fact that a jury has written something down should not cause another juror to abandon their recollection as to what the evidence was. At the conclusion of the case, those notes will be collected and they'll be destroyed, unread by myself or anyone else. Additionally, I have a procedure that allows for jurors to ask questions during the course of the trial. The way that works is as follows. Without discussing the question with any other jurors, write it down on a piece of paper that does not have any notes on it. At the conclusion of the witness's testimony, I will bring up any questions and I'll go over them with the lawyers. If it's an appropriate question to ask, we'll then ask it of the witnesses. And I'll then allow the lawyers follow-up questions on those topics once the witness leaves the stand. It's too late to avail yourself of that once the witness leaves the stand, it's too late to avail yourself of that process. So if you need time to write the questions out, let me know and I will give you sufficient time to write out any questions. We are ready now to go forward with the opening statements of the lawyers. Remember that what the lawyers say is not evidence, and you should not consider as such. The purpose of the opening statements is to give the lawyer a chance to tell you what evidence they believe will be presented during the course of the trial, or give you an overview of what they feel the case will be about. Counsel for the state has the opportunity to go first. Counsel for the defendant then has opportunity to follow that opening statement. Or if he wishes, he could defer that opening statement until a later point in the trial. Ms. Brennan, you may proceed. So all of that sounds like nothing matters in the end but the evidence. It sounds like the testimonies don't make any difference. It's what's the evidence. So in this case, as you listen, where is the evidence? Because that's what he's telling the jury to rely on. The evidence. Where's the evidence? That's what we need to find out, since y'all the jurors, right? Okay, Ms. Brennan, thank you. May it please the court, counsel, members of jury, by now you all are well aware the defendant has been charged with 2 counts of kidnapping, 2 counts of carjacking with a firearm, and 2 counts of robbery with a firearm. And those charges arose out of an event that occurred right before midnight last August 12, 2001. You're going to meet Mr. Nevins and Mr. Wintle. They are the victims in this case. And they're going to tell you that on the day, it's Sunday, that they were earlier that afternoon, had gone to a club for some sort of event that was there. They had driven together in, oh dang, now they use their first names. Girl, I said I was not going to use the first name. So that's Mr. Nevins, but they have his first name there, which is messing me up because I don't want to use their whole name. Okay, they had driven together in Nevins' car and parked towards the back of the parking lot. They'll tell you a little bit about the parking lot that's there at the establishment. They were there till almost midnight, and will tell you that as they were leaving, Mr. Wintle was driving. He was the designated driver. He stopped drinking earlier in the evening so that he could be the designated driver. And they'll tell you they got in the car. They started the engine. They were just about ready to go when the defendant approached Mr. Wintle and knocked on the window of the driver's side. Mr. Wintle, not knowing who it was, knowing people in the club, thought nothing of it. He could only see the torso out the window. Unrolled the window. The defendant asked him for a cigarette. Mr. Wintle went to get him a cigarette, and as he went to get hit a, well, girl, this reading. I'm trying to figure out how to keep saying their last names and not their first, so that's what's messing me up. So this brain is working overtime in this reading, girl. Okay. Mr. Wintle went to get him a cigarette, and as he went to get a cigarette, the defendant placed a G to his head, told him to get out the car, get in the back seat of the car, and that he was being taken to a lake. Girl, that lake situation was not in the original report. I'm just giving you a little background information. That lake situation is something that they formulated and came up with later. That was not in the original report. But now this is what they're saying when trial comes. And that he was being taken to a lake. And mind you, there's a lake right behind the club. Mr. Wintle, not knowing who it was, knowing people in the club. Oh, girl, I already read that. Meanwhile, oh, okay. Mr. Wintle climbed from the front to the back seat of the car. Mr. Nevins, meanwhile, is in the passenger seat. Another black male comes up, gets Mr. Nevins out the passenger seat, and puts him back in the back seat of the car also. Now, when they say another black male, the black male that you really need to have in your mindset is that he's lighter than light. Don't even look black at all. He looks, let's give some examples of how this man looks. He looks like maybe Tom Joyner, light, bright like that. Maybe Alicia Keys, bright. Maybe Sinbad, bright, light, bright. He does not, you're not just going to just keep recognizing him as a black male. But that's what they kept saying during trial. His nationality could be black. He could have been white. He could have been like Hispanic. There's no way to really know. But I think by them constantly referring black male means crime, means because of our, basically the way we've been groomed in society, black means criminal activity. But if they were describing it right, it's not just another black male. He looks nothing like a freaking black male. Okay, another black male comes up, gets Mr. Nevins out the passenger seat, puts him in the back seat of the car also. So, Mr. Wintle and Mr. Nevins are now in the back seat of the car. The defendant goes to drive the car. Now, the defendant is Marchello. Okay, so the defendant goes to drive the car but can't because it's a stick shift. So he changes seats with the other man involved in this case. This is how they're making Marchello the head of this crime. Okay, said that Marchello intended to take that car, but he could not take the car because, oops, I can't, I'm carjacking you, I'm taking you somewhere. Oh, I can't drive a stick. Come on, cuz you gotta drive. I can't drive. Okay. So he changes seats with the other man involved in this. That's unknown. That's never been caught. Lies. He's been caught. But that's a lie. That's unknown. That's a lie. I'm pointing this out to you. That's never been caught and gets in the passenger seat. So the defendant is now in the passenger seat and still holding the G on Mr. Wintle and Mr. Nevins, threatening them, telling them that they're going to be illed, telling them it's the end for them, pointing the weapon at them. And they start to drive off out the parking lot. Mr. Wintle and Mr. Nevins will tell you, obviously, this shook them up quite a bit. That they were sitting back there not knowing what was going to happen to them, not knowing what was going on, and having a G pointed on them virtually the whole time by the defendant. As they attracted the defendant demands that may, okay, I don't understand how that's written, but as they attracted, the defendant demands their wallets from both Mr. Wintle and Mr. Nevins, and which the victim complied, gave up their pilots, it says pilots, I guess that's a typo, gave up their pilots to the defendant and the co-defendant. An unknown co-defendant, not unknown, they just got to protect him. Remember this. That co-defendant turns state evidence. They got to protect him through the whole case. Remember. So he's not unknown. Though they're telling us during trial he's unknown. Okay. He was driving the car. Fortunately, they are driving somewhat near the club still. I think they were on Westmoreland and Livingston. And the driver runs a stop sign, and OPD is right there and goes to stop the car for running the stop sign. Not knowing what's taking place inside the car, but for running the stop sign there, follows the car off Westmoreland down to, I think it's Beach Street, which is a dead end. At which time the officer, two officers in the patrol car, Officer Rivera and Officer Savage, and they'll tell you they're merely stopping the car for running the stop sign there at Westmoreland and Livingston. When the car stops at the end of Beach Street, which is a dead end, all of the sudden the driver's side door and passenger side door fly open. The defendant and the co-defendant bail out and start running. Now, it is proven Marchello, that was in the passenger side, never ran. Never ran. The defendant, as the driver, ran. And they claimed got away, was never brought up on charges, never arrested. It's over for him. But that was a lie. They arrested him. I don't know if they fully arrested him, but they caught him. But it says all of a sudden, the driver's side door and the passenger side door fly open. The defendant and co-defendant bail out and start running. So Officer Savage and Officer Rivera like, hey, what's going on here? Something's up. We're merely stopping them for running the stop sign and they're running. Officer Rivera will tell you he took off after the defendant. And Officer Savage was clearing the car, making sure there was no other occupants in the car, and actually took Mr. Wintle and Mr. Nevins out the car, had them come out the car at G Point, not knowing what had taken place, what had just happened to them. They were immediately telling him, we were just robbed by these guys. We were just carjacked by these guys. They just took our wallets, took our car. So as this is being pieced together, backup is called. Officer Rivera and another officer are able to catch the defendant within 5, 6, 7 minutes of him bailing out. That is a bold-faced lie. Wasn't no 5 to 6 to 7 minutes because he never ran. He was right there. He got out the passenger side. It was right there. They never ran and chased him nowhere. But that's a lie. Okay. Minutes of him bailing out of the car. He's caught in the area. What area? What area? This is aggravating me because they're lying. Okay. He's brought back, which is another lie. He never left, so he couldn't be brought back because you never left. And both Mr. Wintle and Mr. Nevins positively identify him as the man who at G Point carjacked them, kidnapped them, and robbed them. They were absolutely 100% positive in their identification. But why the hell they ran off? That's what I'm not understanding. After this whole ordeal happened and they were subpoenaed to court, they ignored those subpoenas and moved away from Florida to another state. They ignored subpoena after subpoena to come in and tell about this that happened to you, to get this man. They ignored those subpoenas, never came to court, and moved states until trial came. And when trial came, nobody showed up but Mr. Jackson, the defendant. Nobody showed up but him. So they were supposed to drop the charges because there was nobody there to press charges against them. That's when Marcello's own lawyer said, hold on, Judge, we got to continue this case so I can go out of town and subpoena these two back to court That's when he forced them to come to court. Those guys never wanted anything to do with this. That's why they tried to evade. They actually were supposed to be a suspect themselves. Once you listen to this whole thing, they, by the skin of their teeth, got out of this. And they became somewhat the victims. But they knew they didn't want to come to trial because we ain't really no victims. That guy wasn't robbing us. He wasn't kidnapping us. He was taking us in the club. I mean, sorry, not in the club. He was taking us outside the freaking darn club to go get right, to do all of that and come back to the club to see this show. That's what they were in that car for. But the cousin, the one that's never found, quote unquote, never found, runs a stop sign. And that's where everything went down drain. But they didn't want to be bothered with this. So, okay. Officer Rivera and another officer were able to catch the defendant within 5, 6, 7 minutes of bailing and bailing out. Oh, they got this writing crazy. Within 5, 6, 7 minutes of bailing out of the car, he's caught in the area. He's brought back. All of that is a lie because he never left that scene. So him being caught and him being brought back is a lie. Okay. He's brought back, and both Mr. Wintle and Mr. Nevins positively identify him as the man who at G Point carjacked them, kidnapped them, and robbed them. They were absolutely 100% positive in their identification. Prior to the defendant being searched, when he's brought back, Mr. Nevins tells the officer, I had 3 $20 bills in my wallet. That as well as a lie, because in their testimony, they say 80. They don't say 3 $20 bills. So she's putting a lot of lies together in this opening statement, the state's attorney. Okay, had 3 $20 bills in my wallet, and they were not there anymore because they bailed out of the car. You'll learn they dropped their wallets right there when they bailed out. And the victims went and got their wallets, and Mr. Nevins was missing 3 $20 bills. Later you find that's a lie as well. So they're saying the driver and Marchello dropped both of their wallets and ran. They both ran. Driver never caught. Marchello caught 5, 6, 7 minutes later. Okay, and that's how they both dropped the wallets. Okay, that as well is a lie, because one passenger, I believe that's going to be Wintle, had the wallet on him. When the cop later in his testimony says that he asked for identification, he pulled the identification out of his wallet. He had his own wallet. Okay, the second one, which is Nevins, they said that his identification, and you'll find this out later, was found on the floor of the car. He says the ground. We're about to get to that. I'm getting too far ahead of myself. But both of their wallets were found in the car with identification. Okay, he's brought back. Mr. Nevins tells the officer, I had 3 $20 bills in my wallet, and they're not there anymore. And that 3 $20 bills as well does not align, because they did not say that off rip. In their initial reports, they wrote 80. They said Marchello took 80 from them. Okay. And they're not there anymore because they bailed out of the car. You'll learn they dropped their wallets right there when they bailed out. The victims went, got their wallets, and Mr. Nevins was missing 3 $20 bills. He told the officer when they searched the defendant, lo and behold, they found 3 $20 bills on him. That's a lie. It's a lie. Lo and behold, they found 3 $20 bills on him, And what they really did is went back to them and said, here's your affidavit back. He has $60 and y'all wrote 80. So amend this. Write in 60. They both, if you see it, is scratched out. Write in 60, initial it, and one initial with the smiley face. That money does not align, but they're saying that it does. And they're telling this to the jury. Okay, lo and behold, they found three $20 bills on him. Exactly what Mr. Nevins said was taking out his wallet. Girl, lie. I'm confident after you hear the testimony from Mr. Nevins, Mr. Wintle, and the officers that conflict one another involved in this case, that you will find the defendant is guilty as charged on each and every one of these counts. Mr. Sims, thank you, Your Honor. May I proceed? The court. Yes, sir. May it please the court and the counsel, good morning. Ladies and gentlemen, thank you Thank you for returning. I'm Mr. Sims, and I represent Mr. Jackson. Again, I just urge you to remember to listen to the rest of the story. What you are going to know unequivocally is that on August 12th of 2001, Mr. Nevins and Mr. Wintle were at the club. I'm leaving the club name out. And they spent in excess of 6 hours there by their account. What you're going to know is that my client, Marchello Jackson, lives in the area where the car was stopped. Probably a block and a half from where the car was stopped on West Jefferson Street. You will find that there is not one shred of physical evidence to corroborate that Mr. Jackson was ever in that vehicle. You will find there's not one shred of physical evidence to indicate that there was ever a weapon initially utilized in this case. Let me reread that. You will find there's not one shred of physical evidence to indicate that there was ever a gun utilized in this case. However, at the end of this case, I'm sure that you're going to find that Mr. Jackson was in that car. And in fact, there was a gun. And you're going to find that from a very unlikely source. And we're going to talk about that at the end of the case. And I think the most important part of this case will come down to two simple words. And the reason these two simple words mean so much, we'll talk about at closing. It comes down to two simple words that are just words to indicate one simple sign. The two words are happy face. This is what he based this whole trial on. Happy face. And one simple sign is right here. And that's when he draws a big happy face and circles it on this big tablet. At the end of this case, you're going to ask yourselves, what in the world is that all about? And when you think about it logically and completely and look around the edges and underneath the evidence and to the side of the evidence, you're going to find that in and of itself, along with a couple of other things that I'm not going to talk to you about yet, is enough for reasonable doubt. There's a lot of reasonable doubt in Marchello's case. It's enough for reasonable doubt. A reasonable doubt where you're going to say something happened there. There was some crime going on. It's not what they're saying. That's exactly true. That's exactly true. It's exactly true what he said. There was some crime going on. It's not exactly what you're saying. There's a reason you're going to find reasonable doubt, and it's very simple. It's because Marchello Jackson is innocent of this crime. So let's get right into it. Thank you. The court, call your first witness. This is where it gets good, girl. They call in the two guys that ran off, that wanted nothing to do with this case. They're here. They about to take a stand. I'll be right back. Actually, guys, what I'm thinking I'm going to do is because I just checked, this live is now an hour and 10 minutes. I know it's already hard enough to get people to watch my longer videos and longer content. So if I make it too long, because to read through their testimonies from like it's like 60 pages. And I'm not the greatest reader. I'm sorry, as y'all can see. So I better stop this video here and start a new live that just has only their testimonies in it, the two guys. So that we can keep that. If you get a little bored, you can start a new video or something like that. That way you won't have to search through for what I'm telling you and stuff like that. When I put my notes in there, pinpointing where the inaccuracies, where the conflicts of the conflicting comes in, because I'm going to pinpoint and highlight those things for you. So we should stop this live here. And in just a few moments, I'm going to start a new live. Thank you. If anybody did tune in, I do see 0. So that's fine. That's fine. But if anybody did tune in, thank you for being here. Most times on my lives, the algorithm does not show my lives as much as my short content that gets me the most views on my channel. And then my regular long form videos that are usually under 30 minutes get pretty good traction. But a long live like this is not going to give me that great of traction. But that's what we're working with until I get me a new device. So I will talk to you guys in just a few minutes. Hiss, your girl Cadillac.